USCIS has just announced the disappointing news that it has reached the cap for the FY2026 H-1B quota. What happens to cap hopefuls who were not selected? If you weren't selected in the FY2026 H-1B lottery, you have several options to maintain your status or continue working in the U.S. Here's an in-depth look at the alternatives available. F1 status. If you're on F1 status, consider enrolling in a higher education program. This can be a strategic step, especially if your OPT is nearing expiration. If you have already used up your OPT options based on prior study at the bachelor's or master's level, you can renew your OPT options by enrolling in a higher degree program. For instance, a bachelor's graduate can enroll in a master's program, and a master's graduate can enroll in a PhD program. Certain universities have even started to offer remote PhD programs with the possibility of immediate internship authorization, colloquially known as Day 1 CPT. 2. Work with a Cap-Exempt employer. Cap-Exempt employers, such as higher education institutions and nonprofit research organizations, offer another avenue. If you secure a position with such an employer, you aren't subject to the H-1B cap. However, transferring to a cap-subject employer later will require you to enter the H-1B lottery again. All universities hire professional staff for non-teaching positions, and the vast majority of universities sponsor H-1B workers. So one good avenue to secure cap-exempt employment is to look for a job on a university-centered job site like Higher Ed Jobs or the Chronicle for Higher Education. 3. Country-specific options. Depending on your nationality, you may have specific visa options. H-1B1 visa. This visa is for Chilean and Singaporean nationals, focusing on specialty occupations. Standards are very similar to regular H-1Bs. TN visa. This visa is for Canadian and Mexican nationals, based on the USMCA, formerly NAFTA. TNs are not available for all jobs, but rather for only a limited number of designated professions. E3 visa. This visa is exclusively for Australian nationals, and is similar to the H-1B in requirements. 4. L1 intracompany transfer. Ideal for those within multinational companies, the L1 visa is for managers, executives, or employees with specialized knowledge. H-1B cap hopefuls can secure qualifying employment, i.e., a managerial or specialized knowledge job, at an overseas office of a multinational company that has an active U.S. office. This option requires careful planning as there are numerous pitfalls. The L1 visa category doesn't have an annual cap. 5. J1 visas. This visa can be an alternative, especially for professors, research assistants, and scholars. It is especially suitable for teaching, research, and other academic roles. 6. Dependent spouses. If your spouse is on a different visa type, L1, H-1B, etc., you might be eligible for work authorization as a dependent spouse. 7. Green card options. Exploring various green card pathways can offer a more permanent solution. The eligibility and process depend on individual circumstances, but it can be an accelerated path to work authorization and permanent residence. Indian and Chinese nationals facing severe backlogs of their green card should be cognizant of spousal cross-chargeability, which can be of tremendous help to eligible backloggers. 8. Working remotely. In the wake of COVID-19, remote work has become more feasible. Working remotely for a U.S. employer from abroad is a viable option while waiting for another chance in the H-1B lottery. 9. L1. These options are for highly skilled or qualified workers or performers. For each of these options, it's advisable to consult with an immigration attorney to understand the nuances and ensure compliance with U.S. immigration laws. Additionally, staying informed about changes in immigration policies and regulations is important for making informed decisions about your future in the U.S.
If you would like Tewary Immigration Law's help on your immigration filing, please email us at info@tewary.com. Our attorneys are licensed in New Jersey and represent clients on immigration matters in all 50 states. This video is for informational purposes and should not be considered legal advice. Speak to an immigration attorney before applying this information to your specific case.